Good afternoon. The Senate Judiciary and Public Safety Committee will come to order. Today is Monday, March 24th, 2025, and we do have a quorum present. Members, we have a lot of bills on the agenda, but most of them we are here for very narrow jurisdictions on re-referral. So we're going to try to keep our testimony and our deliberation focused on those provisions within our jurisdiction. We're going to start with Senate File 2119. That's one of Senator Kupec's bills. We're going to dub today Senator Kupec Day at the Senate Judiciary Committee. So 2119 members, we have testifiers Ben Klinger and Sean Krizaj. If you would come on forward, maybe you just did. Terrific. The plan or the intent is to lay the bill over for possible inclusion in the omnibus bill. Senator Kupec, whenever you're ready, you can give us a brief description of the bill, and then we will take your testimony.
Absolutely. Thank you, Mr. Chair. This is the one here that is not here on a referral from another committee, so this is all yours. So we're looking for some funding for emergency managers. So Minnesota communities rely on local emergency managers to prepare for, respond to, and recover from disasters. These professionals are the backbone of our public safety coordination during times of crisis. The role of local emergency managers is statutorily required under Chapter 12 of the Minnesota statutes, yet local emergency management offices have historically remained without any state support and rely heavily on federal grants. With the yearly trend of reduced federal funding and the unknown future of the federal emergency management grants, of which these positions are currently funded by, many counties, particularly those in rural areas or with smaller tax bases, are facing difficult decisions and potentially reducing or eliminating of their dedicated emergency management role, effectively weakening our state's ability to respond to disasters, putting lives, property, and economic stability at risk. Emergency managers are vital before, during, and after disasters. They develop, update emergency response plans, conduct preparedness trainings, coordinate active threat drills in local school districts, implement preventive measures for emergencies that range from cybersecurity threats and terrorism to natural disasters. During a crisis, they activate emergency operation centers, coordinate evacuations, manage shelters, collaborate with partners like the American Red Cross to ensure Minnesota receives the services and care they are needed for their communities. After disasters, emergency managers oversee recovery efforts, including securing financial assistance and restoring infrastructure to long-term community rebuilding. Senate File 2119 establishes funding to ensure that each county, tribe, and city of the first class has the resources necessary to employ and equip dedicated emergency managers. And I know coming from my previous career, working pretty closely during times of flooding or other natural disasters, or just in preparedness for the storm season, emergency managers play such a valuable role in protecting our communities.
Thank you, Senator Kupec. Let's start with Ben Klinger. Go ahead and just identify yourself for the record and give us your testimony.
Thank you, Mr. Chair, members of the committee. My name is Ben Klinger. I am the Winona County Emergency Management Director, and I also serve as the chair of the Southeast Minnesota Emergency Management Joint Powers Board. Emergency management covers a broad spectrum of planning and response duties. In the past, you've heard about a lot of them, including natural disasters. Emergency management also gets called upon during other large-scale public safety events. In 2023, Winona County responded to a missing person call. During that investigation, Winona County Emergency Management coordinated and managed numerous search missions. Some of these searches involved over 1,000 volunteer searchers. Emergency management coordinated resources from as far away as Texas, helping with the search. This allowed law enforcement to focus on the criminal investigation. But emergency management can't perform these essential duties without an adequate funding stream. There's a lack of stable and substantial funding for local emergency management programs, which also includes planning, training, and other operations. Local governments across the state are heavily dependent on federal grants for emergency management. Winona County's emergency management program grant was $28,000 per year, but was recently cut to $20,000 per year. The state legislature does not appropriate any state general funds to help pay for our daily operations, even though counties are mandated to have an emergency management director. It's apparent as of late that natural disasters are not only increasing, but increasing in intensity in Minnesota. In 2024, Winona County had one federal disaster declaration. This past year, 15 of the 16 counties in southeast Minnesota had a federal disaster declaration, and several had state disaster declarations from other events as well. If this funding initiative is approved, emergency managers across Minnesota will use the funding in a variety of ways. Some counties only have part-time EMs that could transition to full-time emergency managers. Full-time emergency managers may be able to add part-time staff to help with extra duties. Currently in Winona County, I am a one-person office. My duties and responsibilities follow the same guidelines and training standards required in large metropolitan cities. We all know that emergency management is a critical government function. Emergency managers cannot prevent emergency or natural disasters from happening, but we spend much of our time preparing for these events. We perform exercises and drills to prepare our vulnerable communities for emergencies. We cannot properly prepare a community without adequate funding. Thus, we leave our communities vulnerable. The burden falls on us if that worst day occurs in our community and they are not prepared. It is important to note that we have been making this request for several years, but with the uncertainty at the federal level, it is more important than ever. Thank you, Mr. Chair and members of the community, for listening to my testimony today.
Thank you, Mr. Klinger. Chief Cruzat, did I pronounce your name right?
Cruzet, thank you.
Cruzet.
Good afternoon, Chair Lutz and members of the committee. I'm Sean Cruzet, and I'm the City of Duluth Fire Chief and Emergency Management Director. Thank you, Senators Kupec, Howe, and Clark for co-authoring this important emergency management bill that supports all 87 counties, 11 tribal nations, and 4 cities of the first class throughout Minnesota. This proposed $12 million request will be distributed by the Commissioner of Public Safety in the amount of $117,000 per agency. My name is Sean Cruzet, and I'm the Fire Chief and Emergency Management Director for the City of Duluth. I'm speaking today on behalf of the Emergency Management Directors for not only the 4 cities of the first class in Minnesota, but also the 87 counties and 11 federally recognized tribes that are my emergency management partners, colleagues, and friends. I am currently a member and former board member of the Association of Minnesota Emergency Managers. Emergency management is different for every jurisdiction across Minnesota, and this proposed funding will be used differently by each agency. Some jurisdictions will utilize this funding to hire a dedicated emergency management director, and some will use it for purchasing equipment, conducting training, or the many other functions required to maintain an all-hazards approach to protecting our local communities. Minnesota State Statute Chapter 12 requires that each city shall establish a local organization for emergency management and must have a director appointed by the mayor or by the town board. Similar language in Chapter 12 requires and defines the responsibilities for Minnesota counties. Minnesota state law requires emergency management programs, but does not support them with state funding for ongoing training, planning, operations, or local infrastructure updates that are often required for federal grant submission. Recently, the federal grant funding that we received at the City of Duluth as a pass-through from Minnesota Homeland Security Emergency Management was reduced by approximately 9%, from $20,000 annually to $18,220 for fiscal year 2024. This may not seem like a significant cut, but many programs are barely maintaining the minimum requirements, and every dollar matters. My position at the City of Duluth includes split responsibilities as Fire Chief and Director of Emergency Management as appointed by the Mayor. Some jurisdictions need this funding just to staff a dedicated EM Director, but this proposed funding will not pay my current wages as Emergency Manager or as Fire Chief. We plan on using this funding to keep up with the rising costs of safety equipment that is needed to keep the citizens and visitors of Duluth safe. In the past 10 years, since I've been in an emergency management position for the city, we have seen equipment prices skyrocket to levels that we cannot keep up with in our general operating budget. One example is of our emergency warning sirens spread across 27 miles of Duluth city limits. What used to cost approximately $11,000 in annual upkeep and maintenance for our 31 sirens has risen to $18,375 in 2024. This routine maintenance, battery replacement, and fixing other minor damage is now $155 more than the EMPG funding we receive as that pass-through grant. Emergency repairs are even more. In 2022, we had a siren that was struck by lightning, and that was $16,000 just to fix that one piece of equipment. Another example of what it costs to keep our public safe is our Everbridge emergency mass notification system that we use for shelter-in-place notifications, messages like during the Husky refinery explosion in Superior, and evacuation or seek shelter storm warnings during a tall ships event. That comes with an annual cost of almost $30,000. This is equipment that we depend on to keep the public informed during an emergency that we are currently funded through local means or federal grants that are not guaranteed and are usually underfunded to begin with. In the last decade, the state has seen an increase in severe and damaging weather, and Duluth is no exception. In 2018, we saw a summer windstorm take out power to over 36,000 residents for up to 9 days. In 2018 and 2019, we saw hurricane-force winds registered at 100 miles per hour coming off of Lake Superior, generating 21-foot waves, causing over $30 million worth of damage to the Duluth Lake Walk and Harbor area. We continue to see storms year after year qualifying for both state and federal disaster reimbursements, reaching tens of millions of dollars due to flooding and other damage. This proposed funding is imperative not only for the city of Duluth, but all cities of the first class, all Minnesota counties, and all of our sovereign tribal nations to be prepared for any local disaster that comes our way. We continue to see increased severe weather events, acts of terrorism, civil unrest, and other large group events like concerts, marathons, and festivals that demand increased planning, mitigation, and best practices training to keep our citizens safe. The public expects this from our local and state leaders and deserves this increased funding commitment from our elected and appointed officials. If we are doing our jobs properly, the general public will never notice all of the planning and preparation that it takes to successfully respond to any hazard that is thrown at us. They will, however, be very aware when we flounder in our response to an emergency because we are spread too thin, supporting partners across the state, cannot focus on emergency preparation due to multiple job duties, and general inefficiencies brought on by lack of funding. I appreciate your time today for your support and ask for your support in passing Senate File 2119, appropriating funds to keep every citizen and guest of Minnesota safe. I stand for any questions the committee may have.
Thank you, Chief. Appreciate your testimony. I had a question for staff, because the bill on line 1.11 states that the amount is added to the base appropriation. Do we know if we currently have a base appropriation for this?
Mr. Chairman and members,
Mr. Turner.
I'm not aware of a base for this. I could be wrong. I've got a phone call in, but I think it's probably going to be too late for now. However, is anyone getting any money now for this?
And we'll ask the testifiers. I think I heard them say there's no state money being paid for this, but anyone, any of you? either of you
Correct,
aware?
Mr. Chair, and members of the committee. We
Chief, sure.
currently don't have allocated funds from state Homeland Security Emergency Management. The money that we get is a pass-through fund from federal grants. Counties get a different amount based on population. Cities of the first class and tribes get a set amount annually, and there was a reduction in that amount this past fiscal year.
So, Chief, when you say a pass-through amount, does that pass through the state or through the county?
Mr. Chair, that passes through the state to the counties, and then the cities and the tribes, we apply to the state, but the grant funding source is federal.
So you don't happen to know, Chief, whether that comes into a specific grant fund that just varies by year at the state, or whether it's a specific appropriation by the legislature to a fund to be distributed as grants.
Mr. Chair, I don't want to speak for HSCM. My understanding is every state is allocated a certain amount of funding by the federal government, and then the states choose how they distribute that. Minnesota uses some of that funds to operate their Homeland Security Emergency Management Division, and then the rest of it is passed through to either counties, cities, or tribal nations.
All right. We're clearly going to have to figure that out when we put our budget together, and this bill will be laid over for that purpose.
Mr. Chairman.
Mr. Turner.
Mr. Chairman and members, excuse me. From what I've heard, but I'll confirm it, it doesn't look like there's a base state general fund appropriation for this activity. And that would mean that this language on 1.11, this amount is added to the base appropriation for this purpose. That would just inform us that this is an ongoing appropriation.
I see.
So if that's of any help.
Okay, thank you, Mr. Turner. And if fully funded, then this will be a $24 million appropriation for the first 2 years for the biennium, and then it would carry into the tails after that, right? All right. Any questions or discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. In reading the bill on the first page, it says that the dollar amounts will be divided equally per every political subdivision and tribe. To me, that sounds a little simplistic. I would imagine some political subdivisions are better resourced than others. And why wouldn't we recognize the need first in different communities? Having a dollar amount that is $117,000 for each individual political subdivision equally, I would imagine we're missing the resource allocation that could be given to some communities that really need a little bit more, and those that are well-equipped, let's say metropolitan areas, they may not need it at all. So could someone explain to me why we're dividing it equally and not referencing it to a per capita ratio or any other type of resource allocation, perhaps apply for referencing the need in each political community?
Senator Kupec.
I'll take a shot at
Klinger.
it. The thought behind it was everybody has a need, and that amount of money would probably make a bigger impact in Winona County than that amount would, say, in a city of the first class. So while it's not broke out by per capita, I could do a lot more with that amount than, say, a city of the first class or a larger county that way.
Well, Mr. Chair.
Senator Limmer.
Sir, you're making my point.
Yeah.
I would think that a little math on the back of an envelope, you might be able to find out where we could direct a larger proportion of the funds to the greatest need and analyze where it may not be needed as much. Giving everyone the same portion of the cookie may not necessarily solve all the problems. And while I'm talking, there's been a lot of talk in reference to the uncertainty of federal funds. There's a definite problem coming up in our state budget with a $5 to $6 billion shortfall already. So let's not just keep focusing on the uncertainty of federal funds, because quite honestly, that hasn't happened yet. But we definitely know there's a serious problem with state budgets in this state. Thank you, Mr. Chair.
Any further discussion from members of the committee? Senator Anderson.
Thank you, Mr. Chair. In that same line where it says equal amounts, it also says eligible county, tribe, and city. I wonder what the definition of eligible is as regards to the commissioner. What makes one county eligible or one county not eligible, or one tribe eligible or not eligible? Is there a certain criteria that's being used by the commissioner or by other state statutes that makes them eligible or not?
Senator Chair Lutz, I think one of the things that makes people eligible, or an entity eligible as the county, they have to have an emergency management director, which is in state statute. Tribes, I really hate to speak for tribes because they have their own sovereignty. They can choose to work with the state or they can choose not to and work at the federal level. So I don't really want to speak for them. Cities of the first class are obviously designed, are designated in state statute by population. Duluth is one of the 4. And so they meet that requirement. Again, we have to have a director appointed by the mayor, in my case, by the board in the county. So I think there are just some parts of Chapter 12 that define what an eligible county is. I believe there was some questions when counties tried to share an emergency manager, whether they'd be eligible then for 1 stipend or 2. I think one of the other things, if I could get back to Senator Limmer's question, there are different needs in different jurisdictions. Some of the counties, smaller counties especially, who don't have a designated emergency manager, need to use this funding to hire a director, and that's an average cost throughout the state of what a FTE, a full-time equivalent position, would be. For a place like Duluth, I have this position already, but we spend a lot of other funding on events. We're a regional hub. We have hundreds of thousands of people come in for events every year. Places like Minneapolis, they have more. I talked about our emergency sirens. We have 31. They probably have 10 times that. So there's expenses that are every jurisdiction needs, but they might be different. How you want to break down exactly, what everyone needs, I guess, would be up to respectfully up to you. But that's the idea behind it, is it's an average cost of an emergency management director for every entity, every county, every city of the first class, and every tribal nation. And then it's not specifically designated to hire a person, though. We have some flexibility to use it as whatever the local needs are.
Senator Anderson.
Thank you, Mr. Chair. Maybe council can help. Do you have a recollection of how many counties have emergency directors or emergency managers that would be affected by this bill? My understanding from what the testifier just told me, that if you don't have an emergency manager or director, you're probably not likely to get money.
Mr. Turner.
Mr. Chairman, Senator Anderson, the bill reads that the money goes to 87 counties. And I would imagine that the counties, if there are counties that don't have an emergency manager, this money could be used for that. Those that do have an emergency manager, the money would be used for other things as noted in the bill. But, and to your direct question, no, I don't know how many counties have emergency managers or how many don't have emergency managers.
So, Mr. Chair,
Senator Anderson.
is that word necessary in this, the context of the fact that all 87 counties will get money? Do we need to have eligibility included in this line?
Mr. Turner. Mr. Turner.
Mr. Chairman, members. Yeah, I don't know. I guess because it defines who gets the money, 87 counties, the 11 federally recognized tribes, and 4 cities of the first class, of which there are 4. The eligibility is defined above that, so I guess there is no reason for there to be each eligible county, tribe, and city. It could be just each county, tribe, and city.
Senator Howe.
Thank you, Mr. Chair. And having been in the past, one of those folks that wore the additional hat as the emergency manager for a jurisdiction. I can see why these funds are desperately needed out there. Because the time that you'd want to expend the funds isn't prior to your disaster, it isn't after your disaster, it's prior to your disaster. And the more prepared you are to deal with it, the smoother things are going to happen, and the more well taken, or your citizens are just going to be better taken care of. I mean, if you look at what happened down in Florida and the response they had there, and then you look at North Carolina and look at the response they had there, it all dealt with how they were prepared. And I think that's a good way to look at it. If we want to spend a few dollars ahead of time or deal with the disaster and the economic impact afterwards, I think that's the way to look at it. So thanks for the bill.
Any further discussion from members of the committee? Not seeing any, Senate File 2119 will be laid over for possible inclusion. Now we're going to go back to the top of the agenda, Senate File 1575. Members, you've been distributed the bill, and there is an amendment in the packet, the A5 amendment. This bill comes to us from agriculture, so the amendment is not an author's amendment. Senator Kupec, why don't you tell us briefly about the bill, and then you can tell us about the amendment, including, well, tell us about the amendment.
Sure. Thank you, Mr.
Senator
Chair.
Kupec.
So for the bill itself, this is Senate File 1575, builds on a commitment by creating an incentive program to help farmers improve nitrogen efficiency, reduce the risk of nitrate contamination on our water supply. The approach in this bill is already proving successful elsewhere. Last year, Nebraska introduced a similar program aimed at reducing nitrogen runoff. Interest was so high there that more farmers applied than that legislature had anticipated, demonstrating a strong demand for solutions that protect water quality and maintain productivity. So Senate File 1575 ensures Minnesota remains at the forefront of both water quality and agricultural innovation by offering incentives to farmers who choose to incorporate emerging biological nitrogen sources and other new technologies. This program promotes solutions that do not leach into groundwater or volatilize into the air, helping safeguard water quality and maintaining yields. The amendment, which was brought forth to my attention by council, just kind of cleans up some language. So it is a purely technical amendment.
Okay, members, the provision in this bill that brings it to us is on page 2, subdivision 6. At the bottom of the page, it's the data privacy provision. The amendment is specifically to that subdivision. Council, anything we need to know about the amendment before we take that up? Ms. Primo?
Mr. Chair and members, the amendment seeks to clarify how this current law, the provision in the bill would work with current law provisions that govern the data collected by entities who are given certain payments by the state. And so it notwithstands that current law provision, because as I understand it, the idea is that the data that's submitted pursuant to this provision would be private or non-public. Oh, and additionally, it deletes the use of the term grantee because, as I understand it, these are not actually grants, they're payments to the farmers, and there's a separate data practices provision that would apply to grantees, so that piece is clarifying.
Ms. Primo, can you tell us exactly what data is collected here that's subject to this subdivision 6 provision?
Mr. Chair and members, it would be the data under subdivision 4 of this bill, and it's the documentation and anything submitted to the commissioner that helps to prove those specific qualifications in clauses 1 and 2.
And what is the reason for making that data not public or private data? Can you help us with that, Ms. Primo?
Mr. Chair and members, that would be maybe a more appropriate question for the bill proponents, since that's specifically a policy choice about why that might be necessary.
Senator Kupec, can you help us with that?
Sure, absolutely. This was actually an amendment that was added on in the Agricultural Committee, the data privacy part, which will relate kind of to the next bill I believe we're going to hear. So some of it is just a matter of it's possible that, you know, you could gain some knowledge of somebody else's commercial actions by getting this data. So it's the idea is to just not let your competitors know exactly how you get an advantage. So.
Not being familiar with farming very much, other than as a consumer, I'm trying to understand how crop nutrient management plans would be valuable commercial data that could be used by competitors. So we're frequently asked to make government data not public. But can you or someone give me any more information on
Well, I
that?
know, Mr. Chair, no, Senator Westrom actually is the one that added this amendment on in the Ag Committee when we did it. It was not in my original bill, so this was added on as an amendment.
Fortunately, we have Senator Westrom with us today.
I know.
Senator Westrom, what is the purpose of making this data not public?
Well, Mr. Chair, the overarching concern or idea is if this was to go forward as a payment to farmers, we want to find the right balance of not having every farmer's name out public. That might be a reason farmers don't either want to sign up for it or don't want to participate in the practice if they all of a sudden have their name and data flowing free across the internet. And so that was the basis or the background behind trying to give it a protected status. What the right balance is part of what we probably need to discuss here. I realize at some point farmers getting payments from the government, especially when they become larger and larger, you know, how do we handle that? And then, you know, if you've got farmer X up by Moorhead and farmer Y down by St. Cloud, and they're, you know, in a sort of sense, they're a competitor. Or maybe closer neighbors, you know, is there a strategic advantage or not? Knowledge is power, and we're trying to find a way to make sure farmers aren't giving up their personal information just for participating in this program, but at the same time, we don't want them to be making a big receipt from the government and then not having adequate oversight by the Department of Ag and others, which I think would have the information to be able to make that determination. So,
Senator Westrom, do you know if there are any other grant programs where the name of the grant recipient is not public? Maybe we have a testifier coming forward who can help us.
maybe somebody else could answer that better from Senate Council or testifier.
Mr. Chair,
Senator Kupec?
I've just been whispered in my ear that the Ag Water Certification Program has a very similar data practices program.
Can we get the statute for that and maybe an explanation for why? If you have a testifier who knows the answer to that question, that'd be fine.
Do you want to come and testify on this bill too?
I don't really want to testify on this, but it'll be the same for ours, so.
Sure.
Come on forward and identify yourself, please.
Thanks, Mr. Chairman, members of the committee. My name's Lee Helgen. I'm the Executive Director with Minnesota Crop Production Retailers. So we're the agricultural co-op and retailers across the state. And so there are several cost share programs where the information on specific producers or growers is non-public or private data that doesn't get shared. So the Ag Water Quality Certification is a good example. Many of us would be modeling off of that, where the idea is if your farm went through this extensive certification process, that data and the practices on your farm wouldn't be made publicly available on that because farmers are very sensitive about the data and their management practices, their nutrient management practices, and the kinds of crop inputs that they put on there. In this case, this is a demonstration project with a new product, and I think many farmers wouldn't want to share that specific information that they were working on that.
Thank you, Mr. Helgen. Any questions? Senator Howe?
Thank you, Mr. Chair, and I'm not quite sure how much of this we can ask questions on, so I'm going to ask the question. You can tell me whether it's relevant or not, but I'm in that.
Please focus on the data practices provision, Senator.
Well, you talked about subdivision 4, and that's where my question is to be a farmer in the state is a qualification. Does that mean I could live in Iowa, own property in Minnesota, and I'd be a Minnesota farmer and qualify? If I could live in, or do I have to live and be a resident of this state to be a farmer in this state? How is that defined?
Typically, I think.
Mr. Helgen?
What you're talking about in this kind of cases is the farmland that's being farmed in Minnesota, right? So this would be a grant to a particular farm operation or grower in Minnesota. So the farmer, they could be servicing acres in Iowa or Minnesota or North Dakota and Minnesota. They could own land in multiple states. The property could be owned by somebody who just rents it out, but the actual payment would go for that farming practice in Minnesota.
So,
Senator
Mr.
Howe.
Chair, so it's not a grant, it's a payment. That's what we clarified earlier. So I think we should stop using that term grant. But, so as long as the land is in Minnesota, it qualifies. So whoever may be the owner, actually it's whoever's farming the land gets the payment regardless of where they live. So it could be a corporation, it could be a person, but it is whoever's tilling the land gets the payment.
Senator Kupec?
Sure, I think the idea is to keep, the nitrogen from running off, so no matter who is doing that, we don't want the nitrogen running off into the field, so it doesn't really matter where that person is based. If they're doing the farming here in Minnesota, we want that practice to be good. I will say we have pretty good corporate farm laws in this state for keeping large corporations out.
Any further questions or discussion from members of the committee? Senator Western?
So, Mr. Chair, just kind of overarching, we had added this amendment language in the Ag Committee with a concern just for farmers if they're going to participate. I think there's still a question of, is this the right way to do it? Is this the best use of money with new technologies, et cetera, et cetera? So, I think there's some other overarching questions, but just want to kind of raise that issue for members. But I think it's important that we try to find the right data protection classification for it if the program was to go forward.
Senator Carlson?
Thank you, Mr. Chair. I've had a conversation with a farmer in southeast Minnesota, and I mentioned the nitrogen issues, and what he was concerned about is the compliance? How do you measure compliance with what they have agreed to? Is there testing done? Is there testing done on the land? And who pays for that testing?
Senator Kupec, very briefly, since that's not a data practices question.
Sure. I mean, right now, the Department of Agriculture, along with the Department of Health, is involved with a lot of well monitoring and working, particularly in the southeast part of the state, to monitor that. This, in a way, gets at the input at the front end to reduce that amount of nitrogen, which we know is a problem. If we can reduce that, then that's what this bill is trying to accomplish.
Senator Carlson.
Yep. Thank you, Mr. Chair. And I guess that's the data that comes off of this to verify compliance is what I'm concerned about, and where that's kept and who can see it. You know, and is there testing, I guess, to verify compliance?
Thank you for tying that together, Senator Carlson. I was missing the data link to your question. Any other questions or discussion? The intent, members, is to move this on to state and local government.
Mr. Chair.
Senator Western.
So, Mr. Chair, and I guess I'd just ask for an affirmation from staff, but my reading of it and understanding and the intent is that farmers would submit their data to the Department of Agriculture or the responsible agency. It's just, and so that agency would collectively be able to delineate, you know, how much came from certain counties and in other areas, but specific data or names of the farmers would be kept at the agency with a data private status. And so that's my understanding and kind of the intent behind it, but maybe council can just affirm that that's kind of where we're going with it. But the agencies, for Senator Carlson's question, compliance, we certainly want them to be able to review and make sure there's compliance and the goals are being achieved if the payments would go out.
Ms. Primo.
Mr. Chair and members, the agency that the Department of Ag receiving the data would have access to the data for purposes defined in this bill. It's just that the data would not be available to the public except to the extent that it needs to be used to complete a report, but that report can't identify any particular farmer. So it's unclear what needs to be withheld from the report because it's not just names that could identify a farmer. If it's, you know, maybe a smaller area, even talking about the location that farmer might reside in, that could identify a farmer. So the agency would have to make that determination to make sure they're not in violation of this specific language.
Senator Western, would you like to move the bill?
Well, Mr. Chair, I don't know. Like I said before, if it does move, I want the data privacy stuff in it. I'm not 100% convinced on the spending yet, so
Well,
I'd be
Senator
happy.
Western, the data privacy provision is in the bill. We just haven't adopted the amendment yet to fix it. So why don't you move the amendment?
I'll move the amendment, Mr. Chair.
Senator Western moves adoption of the A5 amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. We now have a bill in front of us. Senator Western, to your point, the money that's in the bill, should it be appropriated, goes to the Commissioner of Ag, which means the Agriculture Committee can figure out whether they're going to have the resources to fund it. But for now, the bill is supposed to go to state and local government. Senator Western, would you like to make the motion to move this on to state and local?
Well, Mr. Chair,
The data practices provision is in
Mr.
the
Chair,
bill.
I would move it without recommendation.
All right. Senator Western moves Senate File 1575 as amended, be recommended to pass and be,
Without recommendation to pass.
I'm sorry, Senator Western moves that Senate File 1575 as amended pass and be re-referred to the Senate Committee on State and Local Government without recommendation.
There you go.
All those in favor, say aye. Opposed?
No.
Motion prevails. All right, next bill is Senate File 1840. This is also Senator Kupec's bill, and we welcome Lee Helgen back to the testifier table. Members, you're getting the packet distributed right now. There also is an amendment in here. This bill comes to us from the Ag Committee, so it's not an author's amendment. Senator Kupec, would you, wait, and what is our jurisdiction on this matter? Ms. Primo?
Mr. Chair and members, it's a data privacy provision on page 3, subdivision 5.
Senator Kupec, would you please give us a brief description of the overall bill, and then we'll focus on the data privacy provision?
Sure. Thank you, Mr. Chair. Much in the same way, this one also is about a program designed with ag retailers. If you are an ag retailer, you sell fertilizer, and this gives them some incentive to actually be part of another program where they become basically stewards of and advising farmers in ways that they would actually sell less fertilizer to the farmers. But this program then gives money basically to the retailers to be part of this program, certify them, and then go out and help farmers make different decisions about maybe the amount of fertilizer they would need to put on their fields.
All right, and can you tell us about subdivision 5, the data privacy provision, or would you like us to have counsel describe that?
Do you want to do the amendment part first to that data privacy provision?
We'll have Ms. Primo describe the provision and what the amendment would do. Ms. Primo.
Mr. Chair and members, so this is a grant, the bill sets up a grant, and therefore the amendment notwithstands the current law on data related to grants. And the reason for that is that the current provision in the bill classifies additional information as non-public or private data, and withholds it from disclosure, which is a slightly different setup and model than current law.
Senator Kupec, can you tell us what the purpose is of that slightly different setup than current law? Or can Mr. Helgen?
I will test. This one came with the data privacy part already included in it, so I will refer to my testifier to explain why he wanted that included.
Mr. Helgen.
Thank you very much, Mr. Chair and Senator Kupec. So the ag retailers and co-ops are the trusted advisors and the crop input suppliers for farmers. In this, we're asking for grant funding to come to the co-op or to the ag retailer. And it would be based on the per acre evaluation of how we're implementing these 4R practices. So these best management practices being implemented on the farm. So when there's a report that comes that says there was this many acres on, that were adopting these best management practices, we wouldn't want to have that information at the farm level or the farm practice level shared as part of a report. Additionally, at the co-op level, we may be doing testing or providing additional specialized business services. And in a very small co-op, you might be able to determine that. So we think it would be in the best interest for the farmers to protect their data and to not share this information about the business practices, because we want to continue to be in that trusted advisor role, working with the farmers to help them change management practices to reduce overall, to improve fertilizer efficiency and try to meet the state's nutrient management reduction goals around nitrates and phosphorus. So protecting that data is really a key thing for this to be a program that would be successful.
Ms. Primo, can you tell us what the A2 amendment does to the data practices provision in this bill?
Mr. Chair and members, it's mostly clarifying and technical. It clearly notwithstands the current data practices provisions for grant data. And because some of the data listed in the bill seems to include information about natural persons, in order to classify that data, we should use the term private data on individuals. And so that's being added as a technical change.
Any questions about the A2 amendment that's proposed to the bill? Senator Howe.
Thank you, Mr. Chair. And I'm not sure how the amendment affects it, but is this data privacy then, if something gets messed up and there is a water quality issue, that the public cannot find out who gave the recommendation to put that much fertilizer on, or possibly a mistake that contaminated a water source or some sort, that the people cannot find out who gave that recommendation? Is that what this data privacy would do?
Mr. Helgen.
Thank you, Mr. Chair, Senator. Under current operations, if there was an issue like that, the department has regulatory authority to step in on it. In this case, what we're talking about is the kind of a change in management practice, and that's what we're asking to keep, not put into a public report. So if you were going to say there were X thousand of acres where we were implementing strip tilling or doing cover crops or reducing fertilizer by using precision ag, that would all be aggregated, but we wouldn't want to be able to say Senator Westrum's farm was implementing strip tilling and reducing his fertilizer, being able to be identified in that statewide report. The regulatory authority doesn't change. The commissioner will be able to access and audit the co-ops for that, but we just don't want to be that information shared into a public report listing all of that acreage across the state.
Senator Howe, any follow-up? Senator Limmer.
Thank you, Mr. Chair. Senator Kupec, do the farm organizations back this, like the Farm Bureau or the Farmers Union? Do they have an opinion on this legislation?
Yeah, I don't think I can.
Mr. Helgen.
We have not approached all the other farm organizations for letters of support. No one's come and said they are opposed to it. I've definitely talked to them in advance. The 4 Rs are kind of the industry standard best management practices. So that's what we're just trying to advance through that. And this payment structure would be a way for the co-ops to work with the producers and growers to help them get the education, information, and training they need to adopt these management practices.
Okay, thank you.
So the question will occur on the A2 amendment. Senator Carlson, move adoption of the A2 amendment. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Members, we now have the bill as amended before us. I know this isn't, there's no dollar amount in here, and this will go back to, the intent is to move this bill back to Agriculture Committee. Senator Kupec, do you have any idea just how much is being requested for appropriation here from Mr. Helgen?
We've had,
Senator Kupec.
I believe we started at, what, 5?
2.5.
2.5 million. But I believe, in discussions with wherever we're going with the budget, that may be scaled back to a smaller amount. Maybe we can get it going as a pilot program, might be where we finally end up, but I believe it's 2.5 million
What was that per year?
For the biennium.
for the
Total?
biennium. Yes. And it's a grant, so it's one time.
Gotcha. Senator Anderson.
Thank you, Mr. Chair. In the data privacy line 314 to 315, it says document acres submitted for payment in subdivision 4 are classified, and I look at subdivision 4, and it talks about the 4R nutrient stewardship certificate program. Is that a program that is then is the Department of Agriculture supporting the 4R nutrient stewardship certification program? Because I've not heard of that being mentioned by the Department of Agriculture.
Mr. Chair.
Mr. Helgen.
The department does not have a position that I know of on the bill. It was not included in the governor's budget recommendation, so this is not something that they're coming out on. They have in the past supported the 4R Nutrient Stewardship Certification Program. It is a program that the Crop Production Retailers Association manages and runs with our Nutrient Stewardship Council. And it's based on an international, national model around fertilizer recommendations. So that's the intention here. And the idea is that the payment would be based on these approved management practices where we'd work with the department to go through and identify which of the practices are really meeting the 4R and then meeting these nutrient reduction goals. So our goal is to try to get widespread adoption of these best management practices working with growers across the state.
So, Mr.
Senator
Chair,
Anderson.
so according to private data practices, it says this has to be a payment according to subdivision 4, and yet you're telling me that the Department of Ag or the governor's budget doesn't include this, so I'm concerned about where this is going to go regarding that, this particular provision in the, not only subdivision 4, but also in the Data Privacy Act. So that's my concern, Mr. Chair.
Senator Kupec or Mr. Helgen, what exactly would the grant money be used for then?
Mr. Chair.
Mr. Helgen?
There are kind of three basic elements that first would be the process of becoming 4R Nutrient Stewardship certified. So the co-op or retailer would go through the 19 standards, become certified for that. There'd be a payment of $5,000 for them to go through that process. That would pay for application fees, audit fees, and staff time that goes into that. Once they're certified or on the path to certification, then the bill would provide payments for the documented acres up to 50 cents an acre. So if you were doing a cover crop, or you were doing strip tilling, or you were doing some precision ag management program that was approved, there would be a payment up to that 50 cents an acre. Additionally, there would be payments to do some of the education and outreach to the growers and farmers to help further explain the 4R principles, practices, and opportunities for them to be more efficient with fertilizer use and application, all as an effort to try to contribute to the goals around the state's nutrient reduction management strategy for nitrates and phosphates.
And then, Mr. Helgen, in paragraph C on line 3.10, it looks like there are also grants to deliver training, but that, unlike in the first two portions of the grants, the amount there is not specified. Is that right?
That's right, Mr. Chair. So we envision that there could be some grants that the department would make to a co-op to host a grower meeting. And that might be a flexible amount that we could work with them and say, and I think some of that is when we come back to, if you're talking about a pilot project that may have less money than this, the education piece and working on trying to promote that, host the meetings, may be a really good strategy for us to build the program, build interest, to get the word out there. And I think we'd work with the department on trying to find out exactly how much it costs to do that and how many of those training sessions we could provide.
And Mr. Helgen, in light of the discussion we had on an earlier bill, question raised by Senator Limmer, where there was a fixed amount of payment that was proposed to be made to individual counties or tribal governments. Here there's a fixed amount on line 2.28 of $5,000. Do you anticipate that that amount would vary depending on retailer? Or is the need different depending on the size of the retailer? Or is that number sort of tied to what any retailer would basically have to spend to do the work? Mr. Helgen.
Mr. Chairman, we anticipated that would be fairly consistent across retail locations. So if you imagine a co-op location serves 300 to 400,000 acres of land, there may be some co-ops that have multiple locations and some that just have one location, but it would really be based on the locations that's getting certified. So there's an application fee, an audit fee, and then the staff time to go through those 19 standards. So we think that $5,000 would provide good incentive, cover those costs to get the facility certified. And then the variable would be on the acreage that they certify.
Any other questions or discussion from members of the committee at this time? Not seeing any. Senator Westrom.
Mr. Chair, where's this bill going, potentially? Is it going back to agriculture?
Yeah, this
or
is requested to go back to ag.
Okay.
All right. Senator Seeberger would move that Senate File 1840 as amended be recommended to pass and be re-referred to the Senate Committee on Agriculture. All those in favor say aye. Aye. Opposed? No. Motion prevails.
Thank you very much.
Next bill is Senate File 1690, Senator Kupec. Welcome to the committee.
Thanks.
Members, we've got at least one testifier. I've got two testifiers on the list. Members, there were 16 testifiers that requested to appear before the committee here today. Unfortunately, we don't have the time, nor frankly would I probably have the patience to listen to 16 testifiers on this, especially since many of them already had an opportunity to testify on this bill at its last stop. I'll also note that the correspondence that was submitted with this bill to the committee, which will be included in the packets being distributed, were identical to the correspondence that was submitted to the prior committee. Since our jurisdiction on this is limited, we're going to focus only on the jurisdiction within our committee. Thank you. And members, you might want to make a note of this. Section 9, subdivision 2, Section 10, subdivisions 1 and 2, and Section 10, lines 28.6 to 28.9. Lines would be page 28. So, Section 10, lines subdivision 1 and 2. And in addition to that, lines, well, actually, lines 6 and 9 are included in subdivision 1. No, page 28, which takes us on to the next page, has to do with Attorney General's role. Okay, so, Senator Kupec, by the way, the intention then is to have this bill move on to the Commerce Committee from here. Senator Kupec, would you please give us a brief description of the bill, and then we'll hear from a testifier.
Sure, I'll give you the 10,000-foot kind of overview here. So this is an electronic waste recycling bill. It would provide Minnesotans with a statewide system for disposing of electronics at no cost to the consumer or to the units of government. It would replace existing Minnesota Electronic Recycling Act that currently only compromises computers, fax machines, computer peripherals, DVD players, video cassette recorders, and video display devices. It adopts a program that would require collectors to accept all electronics with certain exceptions. The program focuses on certain covered products whose brand producers would cover the costs associated with the disposal of these products, but collectors registered under the program would be authorized to collect electronics, whether explicitly covered under the program or not. And it is designed with the intention of eliminating the disposal of these products through curbside solid waste and or recycling programs, and to help keep dangerous waste out of landfills and recycling centers. Many of our counties are not being made whole with their electronic waste recycling, particularly in greater Minnesota, where they have to ship the electronic waste most often down to the Twin Cities. It comes at a great expense. This bill also deals with batteries, which have caused fires. If you go to any kind of just regular recycling center, they deal with 3 to 4 fires per week caused by the lithium battery. So we're trying to particularly take those out of the waste stream and eliminate that. Our regular recyclers have to pay exorbitantly high insurance rates to cover for the case of fires, and also invest in fire suppression, which also just drives up the price of your regular everyday recycling. So this bill looks to aim that, and also also make sure that this stuff does not get into our landfills. And also, many county landfills are getting full, and the more things we take out and recycle, the longer the life on those landfills will be, and the lesser the cost that will have to be passed along to taxpayers to site new landfills and also make up the covering cost for recycling.
All right, and your testifier, I've got you, Mr. Johnson.
Correct.
Go ahead and
Thank you.
identify yourself for the record and present your testimony, please.
Thank you, Mr. Chair and members. For the record, my name is Tom Johnson, Government Relations Director for the Minnesota Pollution Control Agency. Thank you for the opportunity to testify today on Senate File 1690, which is also language that exists in the governor's budget recommendations for the MPCA. Thank you to Senator Kupec for bringing this forward, and also the senator did a great job describing the bill as a whole. So just specifically to the portions that the committee is considering under Section 9, Mr. Chair, before I get to Subdivision 2, which creates the private right of action, just an understanding for the committee of what this section does. In general, it is intended to allow for the recovery and proper management of abandoned, improperly disposed of, or improperly stored covered products. So as you heard from the senator, those covered products are e-waste, batteries, et cetera. And so there are a few different actions that can be taken to recover those materials. One would be under our existing authorities, which you see under paragraph A, where we would issue an order to the person responsible for the abandonment, disposal, et cetera. If that order does not work, we would then go to the product stewardship organization made up of the producers to then manage that waste. If that fails, Mr. Chair, we would then go back to the agency's abilities to go in ourselves and clean up that waste with a contractor. So Subdivision 2, under the purview of the committee, establishes the private right of action for essentially cost recovery for the product stewardship organization in either way, whether it would be the agency cleaning up the materials under paragraph B or the product stewardship organization cleaning up materials under product A or under paragraph A. The stewardship organization would be able to maintain a civil action and be entitled to damages under the paragraph equal to up to twice the actual cost of recovery and proper management. So essentially and that also includes an award of reasonable attorney fees and costs. Moving on to Section 10, Mr. Chair, this is the other private right of action. And this is really intended, and you'll see mostly we're talking about the stewardship organization's costs. Since the stewardship organization is intended on behalf of the producers, fees collected by the producers to carry out the work laid out in the bill, if producers are so-called free riders or are not joining the product stewardship organization, and therefore the producers that are doing the right thing are carrying more of the cost. If that's occurring, then the product stewardship organization would be able to, again, entertain a civil action, or enter into a civil action to recover those costs. And since this is mostly intended to compel the participation of a producer, there's a 60-day lag time where the plaintiff or a stewardship organization would then enumerate which potential producers are not complying. There would be 60 days, and then the action would be commenced. So there's a little bit of time for those producers who are not participating to then come into compliance. Subdivision 2, this is a standard piece of language that is put in almost every, or I think every product stewardship law, Mr. Chair, and it's essentially just making very clear that any of the activities that the producers do to collaborate as they're directed to form the product stewardship organization, to carry out the duties laid out in the bill, that none of that constitutes antitrust activities or unfair trade practices. And then I think the final piece of language, paragraph B on page 28, this subdivision about contracts is really about state procurement. And so if there is non-compliance if there's a contract with a producer that is not compliant with this law, then there's a number of actions that would be taken, including voiding of the contract if that non-compliance was adverse to the extent that it would be exceeded by the benefit obtained by that contract. So, and then this paragraph B is really just if we are getting to that point where this contract is in place with a bad actor, the Attorney General could pull back, in addition to any other remedy, pull back any of that unlawfully obtained money, property, or benefit. So, Mr. Chair, thank you for the opportunity to testify. Happy to stand for questions.
Thank you, Mr. Johnson. Are there any questions or discussion from members of the committee? Senator Limmer.
Thank you, Mr. Chair. I'm trying to follow. I see that up front in the bill, there's definitions, and one of the definitions is stewardship organization. Refers to a nonprofit, but could you give me a little more definition of what that nonprofit does? What's the role? And then, in addition, how does that organization have standing in order to file a civil lawsuit?
Mr. Johnson.
Thank you, Mr. Chair. So the stewardship organization, essentially, the way that these types of laws are set up is we're attempting to, all the end-of-life costs that are currently borne by taxpayers are then shifted to the manufacturers and producers. And so the producers, the most efficient way of doing this is to create this stewardship organization where all the producers are required to, if they produce over a certain amount, they're required to participate in the stewardship organization. And so that is really, it's just the entity that is formed to then carry out all of the duties in the bill, including reimbursement of collection and recycling. As to standing, I am not a lawyer, Mr. Chair. I would say that the stewardship organization is, in this case, already contracting out or doing the work. And so their standing is the work that's already been done, and then they're asking the court to seek a remedy equal to, well, in this case, I think twice the amount of the actual cost of doing those accomplishing those activities.
Council can supplement the answer. Ms. Primo?
Mr. Chair and members, on the standing issue, the bill itself would confer that standing upon the stewardship organization to bring that action against the appropriate party, and then sets up the framework for what they can collect and how much of it.
Any other questions or discussion from members of the committee? Actually, before we do that, I just want to note that we did have a Maria Jensen had signed up to testify. Is Ms. Jensen here, or does she wish to add anything to the testimony today?
She's here, but
Answer
I think
questions or to testify?
she can answer questions if necessary, I think.
All right. Thank you, Mr. Jensen. All right, Senator Howe.
Thank you, Mr. Chair. Can someone tell me how this affects those organizations, those companies that are right now for profit in the business of recycling electronic goods? How do they fit into this framework, or are they out of business?
I think now we're ready for Ms. Jensen to
can
make her
answer the
appearance,
question,
Mr.
but,
Chair.
members, we really want to try to keep the testimony focused on the causes of action provisions that are within our jurisdiction. So a little bit of context here will be helpful, but we're not going to go too far astray. Ms. Jensen, please identify yourself for the record.
Thank you, Chair Latz. My name is Maria Jensen, and I'm the co-director of RECA. We are a business association for electronics recyclers in Minnesota. And just to answer your question, we see this as a huge opportunity. Our members are very excited for this program. Currently, as the Senator Kupec mentioned, the current program from 2007 only covers some items, including items of a certain, screens of a certain size, or fax machines, and it's very outdated. This bill would cover anything with a battery, a cord, or a circuit board. And our members look forward to processing more material, as the shredders and the machines that they have to process this material are only being run at about 25% capacity. Thank you.
Any further discussion or questions from members of the committee?
Chair.
Senator Limmer.
Mr. Chair, I'm aware there might be someone who might oppose this bill in the audience and focus their comments on this very specific area of our jurisdiction. Could we hear from them?
Is there anyone in the audience that opposes the bill on the grounds that are within this committee's jurisdiction? Okay, sir, come on forward. Can I ask you to identify yourself for the record and keep your testimony focused specifically on our jurisdictional issues here, sir?
Thank you, Mr. Chairman. I am Mark Orada. I'm here representing the National Electrical Manufacturers Association. Over 300 member companies, and we produce, our members produce all of these types of products that you're talking about. So I'll keep it very brief. I guess we just heard it will cover everything, which is a concern, anything with a battery, circuit board, or cord. Children's or people's tennis shoes with lights that light up include circuit boards. So one of our concerns is just the broad scope and how are we going to process all this. But more to the committee's jurisdiction, it sets up a very complex system, and it sets up a board of the stewardship board, right? Well, manufacturers are not listed there. We will be heavily impacted by the actions of this legislature if this passes. And yet, the companies that provide this, that are essentially are being told, you will be the ones paying the bill, we don't get called out representation on that board. Now, it does say there are 4 positions, but that is no guarantee that that will happen. And because there are penalties, civil fines, lawsuits that come into effect, we also have concerns, even if it's talking about those folks where the storage is occurring, that the board will need to recover those costs. Well, what's going to happen? They're going to have to go back and figure out how to cover those. If our member companies are the ones paying the bill, then likely we will be drug into that as well. And with all the products that are talked about being covered, we also want to make sure that we would have a voice in copyright laws and licensure agreements and trade secrets, and make sure that as we go through this process, our voice is heard on those very important issues. Mr. Chairman, thank you. Appreciate the time.
Thank you, Mr. Arado. Any further discussion or questions from members of the committee? I'm not seeing any. Senator Umo Verbetten moves that Senate File 1690 be recommended to pass and be re-referred to the Senate Committee on Commerce. All those in favor say aye. Aye. Opposed?
No.
Motion prevails. Thank you, Senator Kupec.
Thank you.
I know that we were the highlight of your day. You can move on to something else now.
Thank you.
Senator Kreun, are you ready for your 2 bills? Senate File 740, House File 747. Minnesota Business Corporations Act. This will wake everyone up in the committee room.
I'll do my best.
Members, the intent is to lay the bill over for possible inclusion. Senator Kreun, why don't you tell us about your bill, and then Ms. Lowe can testify as well.
Thank you, Mr. Chair, members of the committee. This bill comes from the Minnesota State Bar Association, and the bill updates our Business Corporations Act to keep Minnesota current with best practices and developing norms in corporate governance. The bill was carefully developed through a long Bar Association process that included careful study of recent changes to the Model Business Corporation Act, as well as developments in Delaware, which is the leading jurisdiction in corporate law. At the onset, it's important to note that the changes in this bill affect the internal governance of corporations. That is how shareholders, officers, and directors interact with each other. It does not affect a corporation's external affairs, in other words, how it deals with the public. And throughout this, corporations can always organize their corporations differently as they see fit. This would be the default for those companies when they don't do that. Real briefly, Mr. Chair, well, I don't know how briefly, I'll try to make it briefly. Just some real highlights to what is changed in this bill. There's a change to beneficial ownership definition. The definition of beneficial ownership is modified to make clear that a beneficial owner includes a person who owns at least 10% of the beneficial interests of a trust or estate, or serves as a trustee for the trust or the estate. Emergency powers are changed in this bill. They set forth how a corporation can adopt emergency powers in its bylaws, or if no emergency provisions are adopted in the bylaws, what power exists to act in the event of an emergency. Ratification and validation of defective corporate acts. Under the current act, certain defective corporate acts are deemed to be void, not voidable, which means they're incapable of being cured. The proposed amendments here would provide processes for ratifying or validating defective corporate acts, transactions, and stock issuances. Shareholder control agreements. I'm told there was a recent Delaware case law, I can't claim to have read it, that questions the authority of shareholders to govern a corporation by contract by adopting a shareholder control agreement unless such authority is set forth in the Articles of Incorporation. These amendments would allow corporations and their shareholders to highlight those rights in the Articles of Incorporation and authorize dissenters' rights for shareholders who object to the adoption. Mr. Chair, board of approval of contracts. This is again a result of a recent Delaware case law. I won't go into that one in any detail. Optional officer exculpation, which is a very interesting and exciting topic, I'm sure. That one again comes from Delaware, which has extended that to officers rather than just directors. So I take it we're following Delaware's lead in that as well. Inspection of books and records, this one I think is important. Our current act authorizes shareholders, beneficial owners, and holders of voting trust certificates to inspect a variety of corporate books and records. These amendments would add equitable enforcement provisions to beneficial owner and holders of voting trust certificates, which currently do not exist. And then finally, Mr. Chair, plans of merger or exchange. These amendments permit the parties to include in a merger agreement a provision that allows the target to seek damages, including damages attributable to its shareholders' loss of the acquisition premium against a buyer that has breached the merger agreement, such as a failure to close the transaction after all conditions have been satisfied. I don't have any experience in that last one, so I will have to rely on my testifier in large part to explain this more and to answer questions. With me here today is Attorney Kim Lowe.
Ms. Lowe, welcome back to the Judiciary Committee. Go ahead and just state your name for the record.
Thank you, Chair Latz. My name is Kim Lowe. I am a business law attorney here in the state of Minnesota, and I'm also a member of the business law section of the Minnesota State Bar Association and the subcommittee of that business law section that is responsible for keeping track of changes to 302A or our Business Corporation Act. Just for information, the MSBA breaks our acts, our business law acts, into different subject matter experts. So there's different experts who deal with our limited liability company acts, different experts who deal with our corporations acts, and then our co-op acts. You might see me on all of them, but I'm here today for the 302A. A little bit of background. Thank you, Senator Kreun, for kind of going through our background. But the reason we go through this exercise as business law lawyers here in the state of Minnesota is to, one, make sure that our business corporation acts are current, because things are changing around the country. They're also changing here in Minnesota. And our acts are written, they're not written in vacuums. We spend a lot of time throughout all over the country dealing with corporations that are either formed in other states, or our corporations are going into those states and doing that work. And so it's important that we keep our acts as current as possible, or not current. Sometimes things happen in Delaware and other states, we reject those. We don't make all changes. But that's the background on these changes. And a lot of what's important to remember is these are the internal affairs of corporations. These are not the external affairs. So all of these changes really deal with how directors and officers and shareholders interact with each other, and not the external outside world. Senator Kreun did a good job of explaining all the different changes that we're proposing. Some of them, I'll hit the highlights on the ones that I think matter the most. Some of these are just keeping current with other states and Delaware. The emergency powers section is something that is happening throughout all of our corporation statutes because of the situations that have arisen over the years. And what do organizations do when there is an emergency? How do they function? How do they go back and do the work they need to do internally if they're not capable of meeting? Uniquely, the changes we're making to our corporate statute do not align with what happened in Delaware and what's happening all over the country. We have reserved additional powers to the corporate shareholders in the bylaws to make other decisions about what is an emergency and when an emergency ends. That's a unique change that we're making here in Minnesota that will make us different than other states. The other important section that we think as practitioners is being implemented here are the corrections for defective acts. People always ask me, is that like a workaround to get in front of problems? No, it's a really important need. Oftentimes we have corporations that we're dealing with here, closely held corporations that were formed 10, 15, 20 years ago. They're authorizing, articles of incorporation might authorize 10,000 shares of stock, but over the years they've issued 100 or 200,000 or 400,000. They might be to sons or daughters or what have you. This defective acts provision allows us to fix that, where in the past we've had no ability to fix those sort of clerical errors that have happened over time in our closely held corporations. This doesn't happen with our 25 publicly registered Minnesota corporations. It really is happening in our closely held corporations. And that's what this is really helpful for, to help really reduce that, or have a mechanism so we can fix that. I can go line by line to all of the changes if you'd like. I doubt you want me to do that, but I'm more than willing to field any questions that you might have.
Thank you, Ms. Lowe. Appreciate your succinctness. Any members of the committee have any questions for Senator Kreun or Ms. Lowe? See if you can stump the senator.
Don't try, please.
Senator Limmer.
Mr. Chair, did I hear you right? You wanted to lay this bill over?
That's correct, Senator Limmer.
I understand that the other body passed it off their floor 134-0. And I was just thinking that maybe this might be a candidate for separate action on the floor.
Tell you what, if we can send it out of here unanimously, then we'll entertain a motion to refer to the Senate floor, and then we can dual track it in the event that there isn't time to take it up on the floor. Senator Limmer, would you like to make that motion?
Sure, Mr. Chair. So moved.
Before that motion, any other questions? Final comments, Senator Kreun?
Thank you, Mr. Chair, members of the committee. While these changes and others
These changes in this bill are maybe not exciting to most people. They will help ensure that Minnesota remains an attractive place for companies to incorporate and create jobs and do business. Thank you.
Senator Limmer moves that Senate file, House file, again, I just don't like saying the word House.
I feel your pain.
Yeah, it's too many years in the Senate, removed from the House, it'll do that to you. Senator Limmer moves that House File 747 be recommended to pass and be referred to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. All right, thank you, Ms. Lowe. Senator Kreun, Senate File 2338, mortgage foreclosure redemption. Members, that'll be distributed. There is an A1 amendment. I'm going to guess, given the topic, that this is an author's amendment. It is. This is the Committee of Original Jurisdiction. Senator Kreun moves adoption of the A1 author's amendment. All those in favor say aye. Aye. Opposed? Motion prevails. Amendment is adopted. Senator Kreun, if you could give us a brief summary of the bill, please. I'm going to note it's 10 after 2. We do have one other bill after this on our agenda, and it has a number of testifiers. Oh, just one testifier, but a number of pieces of jurisdiction. So I'm going to try to make sure we can get done on time if we possibly can, but we're going to give this bill all the attention that it needs. Senator Kreun.
Thank you, Mr. Chair. And this bill is much more exciting than the last one. Sorry, Kim.
You have to ask Ms. Lowe about that. You still in the room, Ms. Lowe? She was smart. She got out of here very quickly.
This one is about mortgage foreclosures. Chapter 580 of our code governs foreclosures by advertisement and the foreclosure sales resulting from foreclosures by advertisement. These are sales that are conducted by our sheriffs, and the Hennepin County Sheriff's Office handles the most foreclosure sales in the state. And they've encountered a number of situations that are unclear and potentially and in fact harmful to homeowners trying to what we call redeem their home or save their home out of foreclosure. So this bill kind of fills in the gaps and creates some certainty for our sheriffs in conducting the foreclosure sales, and also helps our homeowners stay in their home and exercise their legal rights of redemption. This endeavor started with the Hennepin County Sheriff's Office, but also has had input from Eric Cook at Wilford and Geske, which is a very well-respected foreclosure firm here in the Twin Cities. And then legal aid has come into it as well and contributed a number of suggestions into the bill that are beneficial to homeowners, like I've said. So I won't go through every section in the interest of time. I think the bill seeks to do two major things: clarify the procedural aspects of 580 so that foreclosure speculators do not use loopholes to thwart the interests of both legitimate creditors and homeowners trying to save their homes. And number two, make it easier for homeowners to obtain any surplus due to them after the foreclosure sale and give them the opportunity to use those surplus funds towards redemption. One section I'll specifically call out is Section 1, because I've had a lot of experience with this one. A lot of these foreclosure speculators, and the way it works in these foreclosure situation is if there's equity in the house, you want to be the last in line to redeem, because that's the party who takes the property and then realizes the equity. And so you would see situations where speculators would come in and maybe offer the homeowner, hey, here's $500 if you give me a mortgage, record that mortgage so that they're at the end of the line. This one deals with property taxes, which is even more egregious because they might pay some delinquent property taxes to get a redeemable interest, or even worse, maybe partially pay some of the property taxes to get a redeemable interest. And there's really no oversight or regulation surrounding that. It just creates this weird redeemable interest that they use then to try to redeem the home. So this kind of puts some structure around that, prevents these speculators from creating redeemable interest by doing that. The surplus obviously is the big part of this bill. It helps homeowners to have the ability to use the surplus to save their home, essentially, I guess, to kind of simplify it. There's a number of other provisions in here that I would love to talk about. Oh, dual tracking, that's another big one that will help homeowners. So it clarifies what dual tracking, that's where dual tracking prohibits lenders and servicers from proceeding with the foreclosure while they're negotiating loan modifications with the homeowners. That's what dual tracking is. Here, this clarifies that to give the foreclosing lenders more flexibilities to postpone or cancel the sheriff's sale while that's going on. Before, it was just postpones. And it also gives homeowners more time to look for other options to save the home if they are denied a loan modification. So they might be going down one track thinking that that's what they're going to do, and then it turns out they're denied. This gives them more time to kind of regroup and figure out what to do, which would likely be put their home on the market if they have equity, perhaps, and sell it so that they can realize the equity rather than someone else. The amendment that we passed here in the A1 really does three things. The first one is it's to make every effort to notify the homeowner of the right to claim a surplus, provide some clarification to the sheriff to do that, and it has to be mailed to the property tax statement if there's no street address assigned to the property. The second thing is to take the burden off the sheriff to act like a judge, so they're not making determinations. If they're not certain how to proceed, this gives them a clear avenue to go to the court, kind of throw up their hands and say, okay, we got two competing interests here, and we need some judicial determinations on this. And the third thing, again, it extends the time a homeowner has to seek alternatives to save their home if they're denied a loan modification, as I touched on, but it changes that from 30 days to 60 days, which was a really important component to legal aid here. So I think this is a good bill that I think benefits everybody. There's not heard of any opposition to it. I think it's a fair, balanced bill that provides some remedies to the homeowners, helps them save their home without being overly burdensome on the foreclosing lenders, and and just as important, to help the sheriffs do their job better and to remove clarity. And with that, I would like to turn it over to my testifier, Colleen Daly, with Legal Aid.
Thank you, Senator Kreun.
Ms. Daly.
Yes, thank you. My name's Colleen Daly. I'm an attorney at Mid-Minnesota Legal Aid and have done a lot of foreclosure defense work for homeowners. So my involvement in the bill has been to make sure that in the clarifying the process to help the sheriffs, that we are making sure that homeowners' interests are being protected. One of the main things is, so if somebody's in foreclosure, let's say they owe $50,000, it's being foreclosed, but their house is worth $200,000. Someone comes to the sheriff's sale and bids $100,000. That gives the homeowner a $50,000 surplus because someone bid more for the house than what the homeowner owed. And currently, under the current law, it's sort of unclear, like what happens to this surplus. The homeowner is entitled to the surplus, but unless there's other liens. So if there's junior liens, or there's a second mortgage, or there's other liens that come after the foreclosing lien holder, then it's very unclear to the sheriffs. What are they supposed to do? And sometimes those junior lien holders don't ever come forward. So the Hennepin County Sheriff's Office is sitting on a lot of money that is surplus money, but it's very unclear under the law who that money should go to. So it creates a limited time frame for junior lien holders to make a claim to say that they're entitled to the surplus and for what reason, what gives them that right. But it also requires the sheriff's office to notify the homeowner, because right now homeowners don't even know if there's a surplus. They wouldn't necessarily find that out. So it requires that they get notice that there's a surplus, and it also requires the sheriffs to hold the surplus so that if the homeowner does manage to redeem, and so they can redeem in two ways. One way would be somehow they come up with the money, which happens more often in like homeowners associations foreclosures because that's often a small amount of money, less often in mortgage because that's a bigger amount of money, but or they sell the property. So if they can sell the property for $200,000 and they only owe the bank $50,000, but the bid price is $100,000, like a third party comes in and bids, the The homeowner right now theoretically might actually have to come up with 100, because the way the statute's written, they have to pay the bid price to redeem, but they actually only owe 50. So theoretically, they'd come up with 100, they'd redeem, and then they'd get the surplus back. So it doesn't really make sense to force the homeowner to come up with more money than they really owe and get the surplus on the back end. So it requires that the sheriff hold the surplus during the homeowner's redemption period, and they can apply it to the redemption. So they only really have to come up with the amount owing to the foreclosing party. And like Hennepin County has basically been doing that, but it's not very clear at all in the statute how that's supposed to be handled. So this really clarifies what to do to protect homeowners in that way, to make the process clear, creates the ability for the sheriffs to go to the, file something in court to say, hey, there's confusion here. We don't really know who's entitled to the surplus. Tell us, court. Let's see. Yeah, I think that sums it up unless unless there are questions.
Thank you, Ms. Daly. Mr. Elwood, do you have anything to say that hasn't already been covered by Ms. Daly? We're running short on committee time today.
Mr. Chair, members, Ron L. with Legal Aid. No, other than to just thank the author and thank the sheriff and thank Mr. Cook from Wilford and Geske for allowing Legal Aid to participate in such a meaningful way here.
Thank you, Mr. Elwood. Any discussion from members of the committee? The plan here is to lay this one over for possible inclusion. Not seeing any discussion. Senate File 2338 is laid over for possible inclusion in the omnibus bill. Omnibus bill. Thank you. All right, Senate File 2530, Senator Hauschild. Come on forward.
That's what I just learned now.
Disregard this stuff because those will be the actual lines.
Okay, members, I am going to identify for you the lines in the bill that are within this committee's jurisdiction. So please, it's been distributed to your to all of you. Please write these down. Lines 22.28 to 24.19. 26.25 to 27.14, and 46.16 to 40.16 to 42.30. And these relate to court fines, fees, civil penalties, criminal penalties, data, and some constitutional real property matters. The intent is to move this bill on to state and local government. And I don't see any amendments in the packet. So let's turn to Senator Hauschild. If you would please give us a brief description of your bill, Senator, and then we'll ask you to address the provisions specifically within this committee's jurisdiction. I'll note we do have Aaron Clems from the Minnesota Center for Environmental Advocacy is signed up to testify only to our jurisdictional provisions. Senator Hauschild.
Thank you, Mr. Chair and committee members. For those of you that haven't heard, we found the largest concentration of helium in the world in northern Minnesota. So another exciting prospect for providing the critical minerals and gases that we need for many of the things that we rely on each and every day. Unbeknownst to a lot of folks, helium is in fact not used primarily for party balloons, albeit that's about 3% of the usage. It's actually more primarily used for things like MRI technology, which is about 80% of the use, things like rocket technology, space exploration, and a lot of the future technologies that we'll rely on, like chip manufacturing. So helium is really a hugely necessary material that we need, and we have it right here in Minnesota. Unfortunately, we have no gas framework or regulatory framework for gasification in Minnesota. And so this bill is really getting at a temporary framework while rulemaking happens on how to manage our helium that we found in northern Minnesota. The piece in front of you, section 15, is regarding contested case hearings. Subdivision 1 allows any person owning property that would be affected by a proposed gas resource development operation on federal, state, or local government land having responsibility affected by the proposed operations to file a contested case hearing. Subdivision 2 sort of lays out what's included and what certain elements are included in a contested case. Subdivision 3 requires the DNR to grant a contested case petition if the DNR makes certain findings determining that. Subdivision 4 authorizes applicants to request contested case hearings and requires the DNR to grant such a petition. And then Subdivision 5 governs the scope of those contested case hearings. Section 18 authorizes any person aggrieved by a final order, ruling, or decision of the commissioner to obtain judicial review. Section 19 is regarding civil penalties and criminal penalties. And I believe, Mr. Chair, that's all the parts that I have in front of me. Is that correct? Go ahead.
Mr. Chair and members, there's just one tiny provision on page 40 that classifies some data and adds the well value of oil and gas to the current law. Yes.
Thank you.
All right, let's invite Mr. Clems forward to testify. Mr. Clems, if you would please go ahead and identify yourself for the record and give us your testimony. Please focus on the provisions within our jurisdiction only.
Thank you, Chair Latz. My name is Aaron Clems. I'm the Chief Strategy Officer for the Minnesota Center for Environmental Advocacy, or MCEA. We're a public interest law firm and advocacy organization with over 50 years of experience defending Minnesota's environment and the health of its people. I'm focused on Section 15, the language about contested case hearings. And the reason why is because SF 2530, Section 15, mirrors language on contested case hearings and appeals that's found elsewhere in Chapter 93, particularly Sections 93.483 and 9350, the statutes the Minnesota State Supreme Court considered and then decided on in April 2021, pardon me, in the appeal of the Polymet permit to mine. A contested case hearing is a fact-finding hearing in front of an administrative law judge, which hears evidence from all sides, then issues a recommendation based on the record. In the Polymet case, the DNR denied a request for a contested case hearing submitted by MCEA and others. Contested case hearings, although they are administrative proceedings, are critical for developing the factual record used by appellate courts. In the absence of contested case hearing, the record is established by the agency. On line 23.28 of SF 2530, the clause, quote, "the commissioner finds that," appears. This is exactly the same language in 93.483 the Supreme Court relied on in its 2021 decision, stating that it meant that it was, quote, "the legislature's decision to give the commissioner authority to find that a hearing will be helpful." In the Polymet appeal, even though MCA and others had demonstrated there were significant, probative, factual disputes about the safety and legality of the Polymet permit to mine, the Supreme Court largely deferred to the decision of the DNR commissioner denying the petition on the basis of those 4 words in the statute. And those 4 words also appear in Section 15. Does the legislature want to defer to the DNR commissioner's decision to deny a contested case hearing even when there are serious, substantial, and probative fact disputes? If there was ever a permit decision that cried out for the detailed and neutral fact-finding of a contested case hearing, it was certainly the first permit ever issued in Minnesota for a copper nickel mine. If this language is not fixed by this committee or elsewhere, the first permit ever issued in Minnesota for a gas extraction proposal, whether it's for helium or hydrogen or any other gas, could also be beyond the reach of a citizen petition for a contested case hearing, even if there is significant evidence that conflicts with the DNR's decision. There is a simple solution. You could amend SF 2530 to delete the 4 words on line 2328, quote, "the commissioner finds that." I hope the committee and the author will consider this change. One other simple addition to that section would also improve SF 2530, include tribal governments among other governments that may petition for a contested case by adding the word tribal to line 22.31 before or local. In summary, Minnesotans have learned about how the courts treat appeals of the permitting decisions in SF 2530 through identical language in the Polymet cases. SF 2530 as it stands is prohibitively flawed. We recommend that you reject this bill if it remains as is. As we've stated, the overall premise of this bill is good. We're excited about the prospects for helium in Minnesota, and MCA has been supportive of this process throughout. So it's genuinely disappointing to have to be compelled to make this recommendation today. We'd be happy to work with the author or the committee to make any changes that would improve the bill. Thank you.
Mr. Clems, I just want to make sure I identified the provisions you specifically recommend an adjustment to. Line 23.28, your request is to delete the words "the commissioner finds that," so that the commissioner must grant a petition if the petition is made.
If the petition is made, I'm sorry, Chair Latz, but if the petition is made and it satisfies the three conditions that follow it.
I see, okay. And then what was the second provision that you recommended changing?
To add the word tribal, sorry, Chair Latz, to add the word tribal to line 22.31 before or local.
22.31?
Yes.
Gotcha. That one, frankly, that may be a state and local government
I
committee
think it might be,
jurisdiction
yeah.
more than judiciary. Although it's within our territory here, it's, the provision itself is within our jurisdiction.
It is next.
Are those the two provisions that you're requesting be amended?
Chair Latz, yes.
And if those provisions are amended, what does that do to your organization's position on the bill?
Chair Latz, we would be neutral on the bill at that point.
Sorry?
We would be neutral on the bill at that point, as opposed to being opposed.
Senator Hauschild, I don't think we have any other testifiers signed up, so we'll open this for committee discussion, but let's start with what's your position on the proposal by Mr. Clems.
Thanks, Mr. Chair and members. You know, I'm just sort of gathering this here and now. I would say, if possible, it would be great to hear from the DNR about this removal of, if the, whatever the words were, the commissioner finds that. I'd be interested in hearing their perspective if that's appropriate.
Of course. Is the DNR here? Good afternoon. If you just identify yourself for the record and give us your response, please.
Thank you, Mr. Chair. Members, Mike Liljegren, Assistant Division Director, DNR Lands and Minerals. From the department standpoint, Mr. Clems was correct that it does have fines, that information needed is in there, and that is current with current standing through Minnesota Statute 93. It plays in 93.483, and that is consistent across all of the mining statute.
And could you give me your last name again, please?
For the record,
Spell it for me.
Liljegren, Liljegren.
I just want to make sure I pronounce it properly. All right, Mr. Liljegren, what if an interested person or the petitioner disagreed with the commissioner's determination with regard to the presence of the three criteria that follow? Is there a remedy for that? Mr. Liljegren.
Mr. Chair, members, ultimately, as it goes through, and if there wasn't information that the commissioner deemed necessary for a contested case, we'll move forward, and then ultimately that would come back through a final agency decision on an appeal.
So if the commissioner decided there was not sufficient basis to go with a contested hearing, then it goes forward, commissioner makes a decision, there's an appeal? Is that right?
Mr. Chair, members, that is correct.
And then what is this, who's the appeal to? Mr. Liljegren.
Mr. Chair and members, ultimately, that would be to the appeals court.
And what is the standard of review by the appeals court in those circumstances? Mr. Liljegren.
Mr. Chair and members, ultimately, as the appeal court looks at that and walks through the completed decision, so if somebody were to come forward with a appeal as to the ultimate full decision on the permit that was issued.
No, but there's a standard of review for every Court of Appeals case. And I'm just seeking clarification on what the court's standard of review is. What level of deference must it give to a commissioner's decision? Perhaps Ms. Primo can answer that question.
Mr. Chair and members, in Minnesota, the courts give less deference to an agency interpretation or decision than the federal courts. I'm not exactly sure what that specific deference is, but Minnesota courts have held that if the statutory language is technical in nature and the agency's interpretation is longstanding, then that interpretation is entitled to some deference. But I'm not sure of the entire breadth of the case law in this area.
Mr. Chair.
Mr. Clems.
Chair Latz and Ms. Primo is correct. In this case, though, the language that I was specifically referencing was cited by the Supreme Court to say that it deferred to the DNR's decision because it was the DNR's decision whether or not a contested case would be helpful to the commissioner. There are other agencies, for example, the Minnesota Pollution Control Agency has rules that does not have the same language and would not look to the commissioner as the sole arbiter of whether or not a contested case would be helpful. The 2021 decision by the Supreme Court established pretty strong deference to the DNR's decision in this case, with one exception. They found no evidence in the record on one particular area for the contested case hearing, and they ordered a contested case hearing on one of 5 issues because there was literally 0 evidence in the record to support the DNR commissioner's decision, and therefore they intervened and said there should be a contested case hearing on that particular issue only.
Is there anyone else that can give any guidance, or Senator Hauschild, do you want to give us some indication of your position with regard to the proposed amendment or change?
Mr. Chair and members, from my understanding, this is existing law for the way that we have done things for industry for many years. And so to make a change for a new industry seems like it would be it would be changing things for one industry and not others, or perhaps this encapsulates all. I guess I'm just, without further understanding the implications, I don't know if I would want to make this change, but you all are the Judiciary Committee and sort of the experts on this thing, so I guess I would leave it to you all to determine the impact of this.
Senator Hauschild, were you aware of this particular concern prior to today's hearing? I'm not casting aspersions, I'm just trying to determine how much opportunity there was to.
Mr. Chair, sorry. Yep, Mr. Chair, by chance, I happened to run into one of the folks in the elevator on my way to committee and was sort of informed about this in a 10-second conversation. So I was given a relative heads up, but I didn't have the information right in front of me and fully understand it.
I mean, I just want to make sure that we have ample opportunity to consider the implications, and that you have ample opportunity to consider the implications as well. It seems to me this might be a little larger decision than 10 minutes of committee hearing would warrant, but let's see if there's any. Would Warren? We're going to hand this over to Senator Limmer, apparently. As to the other proposed change here, Senator Hauschild on line 22.3, 3.1, it was recommended that tribal governments be explicitly listed there as well. Are you aware, or what is your thought on that? And have you received any input from any of the tribal governments on that question? Senator Hauschild.
Mr. Chair, members, I have had conversations with the tribes and with the Minnesota, I'm going to say MIAC, I don't know what the acronym is. And this was not brought up by them. We have added other language that the tribal governments requested, and this was not one of them. With that said, again, I don't think I would oppose what is being suggested in terms of adding tribal governments to petitions for contested case hearings. But I guess I would just need to understand why they're not in there. Maybe they're already included as part of the federal, state, and local governments. I guess I'm not sure.
Is anyone here from the tribes that has input on this? I'm not seeing anyone come forward. Well, let's see what the committee has to say, and then we'll decide how we want to move forward on this. Any discussion from members of the committee? Senator Anderson.
Thank you, Mr. Chair. I think that I can't put words in Senator Hauschild's mouth as to what or how he should decide on these words coming forward, but I think it's a little premature for him to have to accept this or even be considering it at this point. I think more time should be given in regarding to thinking about these changes in his bill, and that's not my decision, it's his decision, but I'm just making a recommendation, so.
Any other thoughts from members of the committee or discussion? Senator Carlson.
Yeah, thank you, Mr. Chair. I think inserting tribal in the list of required communications, I think is proper, because I think that's what has been ignored in the past, even though there was tribal land, tribal responsibilities up there. I think we need to specifically say that tribal should be included. So I would support the amendment.
So members, it's 2:40, and I sense that each of these provisions could have, I'm not entirely sure myself, but could have a substantial impact on proceedings, and I'm a little reluctant to make a decision personally without the chief author having had an opportunity to kind of fully think through what this means, and also without reaching out to the tribe for input, the tribal governments for input as well. So what I think makes sense, and Senator Hauschild, look to you for a concurrence here as well, is I'm inclined to lay the bill over and to bring it back on Wednesday. Give us an opportunity to get more input and for you to consider this as well. And then take it up from there. My understanding is if this moves forward, that state and local government is the next stop for it, and they're meeting on Thursday. So I think we could, if it moves out of this committee on Wednesday, there's still time to re-refer it over to state and local and keep it on track in terms of timing. What are your thoughts, Senator Hauschild?
Thanks, Mr. Chair. That sounds like a good plan.
The members, Senate File 2530 is laid over at this time, laid on the table.
Good.
All right, with that said, members, our next meeting is Wednesday, 12:30 here in this room. Remember, we also do have a Friday hearing at 9 o'clock over in this Minnesota Senate building. With that, we are adjourned.
Okay.